Thank you. My name is Brad Peterson, and I would like to welcome you all today to today's webinar. Our goal in this webinar series is to provide you with timely briefings on key topics when you work on outsourcing, cloud, and other business and technology sourcing transactions. Our goal is to provide practical and strategic advice to help you in entering into, governing, renegotiating, and exiting those transactions. Today's program is titled Arbitration Clauses in International Sourcing Transactions. Topics in our series have included current critical issues in sourcing, NSA data collection, technology dispute resolution, aligning incentives through contract terms, ERP implementation arrangements, contracting for cloud, supply chain finance, and the new European General Data Protection Regulation. You can listen to any of those past programs on the Business and Technology Sourcing Events page on mayorbrown.com. You'll find that by going to mayorbrown.com, looking for Business and Technology Sourcing, go to Events, and then type in Webinar under Search All Events. During today's presentation, you will be provided with an alphanumeric code. If you are applying for CLE credit, you will need to record that code on the virtual sign-in sheet that you received with the email with the connection details that got you onto today's call. You will find directions for returning that virtual sign-in sheet on that form. We will read the code in the middle of our presentation and then again at the end of our presentation. We plan to include time at the end of the program for questions. If you'd like to submit a question electronically, please use the Q&A panel in the WebEx. If we don't get to your question during this webinar, we will make every attempt to follow up with you after this program, so leave your contact information. This program is being recorded, as we normally do with these webinars. In a day or so, we will send you an email with a link which you can use to listen to the webinar again or to share with your colleagues. The recording will also be posted to our website. I'm pleased now to introduce today's speakers, Ted Howes, Robert Kriss, and Mark Stefanini. Ted Howes is a partner in Mayer Brown's New York office and is both the leader of the firm's U.S. international arbitration practice and a member of the firm's global leadership team for international arbitration. He advises U.S. and foreign companies in a wide variety of international commercial arbitrations, including arbitrations governed by the rules of the International Center for Dispute Resolution, the International Chamber of Commerce, the Hong Kong International Arbitration Center, and the Singapore International Arbitration Center. Robert Kriss is a litigation partner in Mayer Brown's Chicago office. He's handled many matters involving technology issues in the Internet and has substantial experience with mediation and arbitration and other forms of alternative dispute resolution in business and technology sourcing transactions. He's tried cases before judges, juries, and arbitrators, and has served as an adjunct professor of trial advocacy at Northwestern Law School. Mark Stefanini is a partner in Mayer Brown's London office and a member of the International Arbitration Group. Mark handles major disputes for clients in a variety of sectors, including energy, financial services, and technology. He regularly acts in disputes involving complex issues of contractual interpretation, misrepresentation, and the existence or scope of tortious duties. He advised international clients in arbitration matters before a wide range of arbitral institutions. Mayer Brown's business and technology sourcing practice, as those of you who have been on these webinars before know, is one of the leading practices in helping clients like you improve business operations by sourcing services and technology. And we've advised on hundreds of large-scale outsourcing transactions and similar numbers of cloud and other emerging technology matters. We're ranked in Band 1 by Chambers and at the top of the list by Legal 500. Ted, I'll turn it over to you to talk about today's topics.
This is Bob Kriss. We're having a technical difficulty with Ted's connection. Let me just go over what we will be talking about today.
Wait, do you hear me now, Bob?
Yes, we can.
Yes, we can.
There we go. Good.
Okay. Very good. Let me start over. I was talking about what international arbitration is. I thought it would be helpful to start out just defining what international arbitration is. It is simply arbitration between two companies of different nationalities. And as I understand, a lot of sourcing transactions are international. Any arbitration clause you put in an international sourcing contract is an international arbitration clause. So today we're going to talk about 5 subjects, and if you just go back one slide, one more. First, we're going to talk about why choose international arbitration, and I can put that another way, which is what are the benefits of arbitration over litigation in resolving international sourcing disputes. The second, essential provisions, and these are provisions to include in an international arbitration clause. You must include them to make it enforceable. Then we're going to talk about highly recommended provisions. These are provisions which we recommend you should include in an international arbitration clause for an outsourcing contract to make it workable. Next, we're going to talk about optional provisions, and these are provisions you can add to an arbitration clause on a case-by-case basis. It depends. And lastly, we're going to talk about enforcement of arbitration awards in India and China, because that we know is a particular interest to the attendees to this call. So let's start. The next slide, please. Why choose international arbitration? Why is arbitration, what benefits does arbitration have over litigation in an international contractual setting? People often talk about speed and costs, and it's generally true that arbitration is quicker and probably less costly than litigation. There's no appeal, et cetera. But that's not the most important benefit by far. The 2 most important benefits are the following 2. Neutrality. First of all, neutrality of playing field. When if you have an international contract and you do an international arbitration provision, you're not going to be in litigation in the courts of the foreign country. You're usually in a third-party country. So, for example, if a U.S. company is entering into a contract with an Indian outsourcing company, maybe you agree to arbitration in France. The next issue, the next neutrality is the neutrality of the decision maker itself. When you're in litigation, of course, if you were in litigation in India, if you're in litigation in China, you're before a Chinese judge, an Indian judge, and no one wants to do that. In international arbitration, the decision maker is of the nationality of the decision maker is neutral. So to take that example that I just stated, a French company, a U.S. company, and an Indian company enter into an outsourcing contract. If they agree to one arbitrator, that one arbitrator will be neither Indian nor American. If they agree to a panel of 3 arbitrators, the third arbitrator, the tiebreaker, the chairperson of the tribunal, will be neither Indian nor American. So it provides for that type of neutrality. I should say that if you have substantial leverage over the other contracting party, you can contract for the arbitration to be in the U.S. You can contract for the arbitrator to be American. Sometimes that's hard to do, but if you can do it, you can do it. And if you can't do it, the default is neutrality. The next point, enforceability, is probably the most important point as to why you would choose arbitration over litigation in an international sourcing transaction. There is a treaty. It's called the New York Convention on the Recognition and Enforcement of Arbitral Awards. It's a multinational treaty. It's been around since 1958, and at present there are about 158 countries that are signed on to this treaty, including India, including China, including most of the world. And under this treaty, signatory states are obligated to enforce written arbitration clauses, and they're obligated to enforce arbitration awards. So if, for example, you get into an arbitration with another company, and you get the arbitrators, in the end of the day, they issue an award saying that your company is owed $1 million. The other side doesn't pay it. Well, the arbitrators can't force the other side to pay it. They're usually three elderly people. But what you can do is you take that award, you go to the court of the country where the assets are located, and the court is treaty bound to enforce the arbitration award subject to certain exceptions. So and to be clear, there's no comparable treaty for the enforcement of court judgments abroad. So unless the other side that you're entering into a contract with has sufficient fixed assets in the U.S. or whatever home country you may be residing in, if the other side does not have sufficient fixed assets in the U.S. to satisfy a future court judgment, that court judgment may be not worth the paper it's written on. In other words, international arbitration awards are far easier to enforce abroad than are court judgments. Next, privacy, confidentiality. If you go back one slide, there is somewhat of a misconception. People think that all arbitration is confidential. In fact, most international arbitration is, but it depends on the rules of the particular institution. So some institutions, including, for example, the ICC, do not require confidentiality. So, you can write that into your clause, and Bob will be talking about that later on. But you shouldn't assume that an arbitration is confidential without looking at the rules of the international arbitration rules you'll be dealing with. On the other hand, all arbitrations, international arbitrations, are private in the sense that the public's not allowed to watch what happens. The last one, expertise, quality of the decision maker. That just means that in your arbitration clause, you can decide on specific qualifications for the arbitrator if you want to do that. It's not always recommended, but you can do that. Obviously, you can't do that when you're before a judge, where you're basically subject to the luck of the draw. But again, I want to enforce that enforceability is a very important factor to consider. Now, arbitration clause, the good news is they're quite easy to draft. The bad news is that if you draft them poorly, it's going to lead to some serious problems. First of all, it may preclude the arbitrators from having jurisdiction altogether. Okay, arbitrators get their authority from the contract. If the arbitration agreement is deficient, if it is faulty, the arbitrator won't have jurisdiction. And then what will happen is when you start an arbitration, the other side will challenge jurisdiction, and you'll end up in the courts. So that's a problem. Even if an arbitration clause is not enforceable, if it's not written in a way that is workable, it may lead to court challenges and other added legal fees. I mean, any resourceful opponent in an arbitration will exploit an imprecise arbitration clause. You may win in the end, but only maybe after spending months or even years in courts litigating what the arbitration clause is supposed to mean. So that's another reason why it's important to put the time in up front in drafting your clause. The last, it reduces the predictability. Obviously, if you have a good arbitration clause, you know what you're in for. You know there's not going to be court fights. Next slide. Just very briefly, I want to emphasize that arbitration clause should not be considered as a boilerplate. I often see attorneys do that. They take it from a contract, they dupe it, and they stick it into their new contract. Again, arbitration clauses are not difficult to draft, but every contract's different, and every contract should be considered different. You may want to dupe something, but then you want to go through it and make sure that it fits your potential contract. I said before, arbitration is a creature of contract because the arbitrator's authority derives entirely from that contract. So that means when you're drafting an arbitration clause in an international sourcing transaction contract, you could think of yourself basically as God. You could put whatever procedures, restrictions, conditions you want on the arbitration. That contract will trump the arbitration rules, and that will shape the arbitration itself. I'm not saying you should do it all the time. You should be careful. An overloaded arbitration clause has its own problems. But you want to have a forward-looking strategy. Think about your client. What would happen if there was a dispute under this contract? Is my client going to be richer than the other client? Is my client more likely to be the claimant or the respondent? Is the contract strongly worded in my client's favor or in the other side's favor? These are all issues you can consider. Think ahead. What type of dispute it might be, and that will inform decisions you make on what you put into your arbitration clause. Next. And I'll turn this over to Mark.
Thanks, Ted. I'm going to talk about three of the most fundamental requirements of a valid arbitration clause before handing back over to Ted to deal with the other highly recommended provisions. These are basically defining the scope of the dispute to be arbitrated, ensuring that arbitration is the exclusive dispute resolution mechanism for that dispute, and providing for appropriate procedural rules to govern the arbitration. So in terms of scope, it's essential for an arbitration clause to clearly define the disputes that will be subject to arbitration. As Ted's already emphasised, the scope of a tribunal's jurisdiction is defined by the arbitration agreement. Therefore, unless it's clear that a particular dispute falls within the scope of the clause, there's always the potential for satellite litigation concerning jurisdiction. It may not be possible to obtain an anti-suit injunction to prevent litigation of the dispute in another forum, and the agreement to arbitrate will consequently be ineffective. Now, in the vast majority of circumstances, the best approach to dealing with this issue is to draw the boundaries of the clause very wide to avoid disputes about the scope of the arbitrator's jurisdiction. And it's advisable to take this approach unless there are good reasons not to, as in general, the more complicated the means by which the scope is defined, the greater the potential for disputes. And as you'll see on the slide, there's some, in the middle bullet point, there's some very broad language, any and all disputes arising under or in connection with the agreement or the transaction. Now, if there is a good reason to seek to draft a hybrid clause, you need to think very carefully about certain factors. Things like, is it clear which disputes fall within which dispute resolution mechanism? Do one or more of the parties have an option to arbitrate? And if they do, is it clear what the fallback position is? And if there are dispute resolution mechanisms operating sequentially, is it clear at what point each of them becomes effective? And is the timing of that open to abuse, in terms of delay by a well-resourced opponent? There is some latitude given by arbitration-friendly jurisdictions, including England and Wales. And, disputes over very fine distinctions such as arising under rather than arising out of a contract are likely to be determined in favour of arbitration, certainly in England. But the reality is you don't want to be in the position of having to deal with a dispute like that in court. It'll just waste time and cost. Next slide, please. The next point is exclusivity. In order for a clause to be enforceable, it needs to be clear that the parties intend to give up their right to litigate in favour of the resolution of the dispute by arbitration. Absent this, a party who commences litigation can't be restrained. And the common context in which this issue has arisen is, as set out on the slide, where there's a reference to may rather than shall in arbitration clauses. In general, references to may are likely to be interpreted as permissive, i.e. a party has the option of arbitration but no obligation to submit, and that obviously can lead to problems with enforcement. So use shall unless you intend the clause to be optional. It is sometimes possible to save an arbitration clause despite a reference to may, and there's a recent English Privy Council decision on this that provided some authority under English law for the proposition that any party may submit the dispute to binding arbitration didn't prevent a party from commencing litigation, but obliged that party to later abandon any litigation in favour of arbitration should the counterparty so request. However, again, that's not the sort of dispute you want to get involved in. Next slide, please. A reference to pre-agreed procedural rules is essential for complex international disputes. This is because the rules provide a structure for dealing with the dispute. As Ted mentioned earlier, without that structure, a clause can become impossible to actually enforce. Many arbitration-friendly jurisdictions do have default rules that will allow an arbitration to proceed without detailed procedural rules having been specified, but by necessity those rules have lots of gaps, and the potential for a recalcitrant party to delay or frustrate the process is very much greater. There are therefore really two broad options available in terms of setting the procedural rules. The first is to adopt the rules of a specific international arbitration institution and proceed under the supervision of that institution, or alternatively, you can opt for an ad hoc arbitration where the parties set their own procedural rules or use an institution's procedural rules without supervision by that institution, but you are then relying on going to the courts in order to enforce compliance with those rules. And that can create difficulties and is particularly difficult before a tribunal has been appointed. Next slide, please. Now, I'm sure the people on this call could do a whole additional talk on the various differences between the institutional rules, so I'm going to restrict myself to some very general comments. The 5 institutions on the slide are all very respectable institutions with sensible rules for the resolution of disputes. Choosing between them is likely to depend on the particular characteristics of the likely dispute and the thought process that Ted outlined earlier of thinking about what disputes are likely under this contract, where are the parties likely to be, and factors such as that. One factor that I come across quite often is choosing between the ICC and the LCIA on the basis of the different fee structures they have, where ICC fees are calculated based on the value of the dispute, whereas LCIA fees are based on hourly rates. So, factors like that come into play, but if you're arbitrating under the rules of one of these institutions, you're in pretty good hands. Next slide, please. In terms of the rules themselves, they are sparse when compared to court rules, and a lot is left to the discretion of the tribunal. Generally, the focus is on provision for the appointment of that tribunal and exchange of statements of case, followed by a procedural hearing to determine the next procedural step. They're not prescriptive as regards evidence, but there are common approaches in international arbitration to the taking and giving of evidence, and international standards such as the IBA rules on the taking of evidence are often used as a template in order to facilitate agreement of evidential matters between the parties. As with many court processes, arbitration is likely to involve the exchange of witness and expert testimony, though sometimes in a compendium format where you will have witness statements and expert reports all dealt with together, as well as disclosure or discovery. Now, disclosure is generally much more limited in international arbitration than will be familiar to English or US lawyers, and is generally based on requests for the provision of certain categories of documents, rather than a general duty on the disclosing party to search for relevant documents. Next slide, please. Now on the slide you can see some examples of model arbitration clauses that have been put forward by the ICC and the ICDR, and as you'll see, each is clear and broad in scope, provides that arbitration is the exclusive method of dispute resolution. You'll see they use the word shall be determined by arbitration, and it provides for the relevant institutional rules to apply. So that is a whistle-stop tour of the bare necessities of arbitration clauses, and I'll now turn over to Ted to deal with the sort of highly recommended clauses you'll need to consider in order to make the arbitration process work effectively for you.
Yeah, thank you, Mark. Again, those you must include that. That's not enough. So let's talk about what we recommend you should also include in your international arbitration clause. Next slide. Very important, the place or the situs of the arbitration. Very easy to draft. You can see the place of arbitration shall be blank. Just tack it on to one of those model clauses that Mark just showed you, and that's how easy it is to draft. You can choose any location in the world, anywhere, regardless of the rules you adopt. I should say you don't want to do arbitration in a country that is not a signatory to the New York Convention, and again they are few. There's 150 plus that are signatories, but you can choose anywhere in the world. So, and it doesn't matter what the rules. So if you do the London Court of International Arbitration rules, the arbitration doesn't have to be in London. It can be in Paris. It can be in New York. It can be in Hong Kong. Again, very simple to draft, but there are complex strategic considerations behind the choice of the place of arbitration. Next slide. I'm just not going to go through this too much in detail, but I think this is quite handy checklist of questions you should ask yourself when you're agreeing to the place of arbitration. First of all, and I said this early, usually it's a neutral third-party country. Unless your client has special bargaining power, you can negotiate a home county arbitration. Next, very important, and I just said this, the place of arbitration has to be a signatory to the New York Convention. Country with a modern arbitration statute, reliable judicial system, these things, a lot of them is just common sense. You want to avoid developing countries, Asian countries other than Singapore, Hong Kong, and countries of the former Soviet bloc. And that's quite a generalization because there are countries in Asia, other countries in Asia, I'm sure, and a lot of countries in the former Soviet bloc, I wouldn't include Russia in that, where you'd be okay to arbitrate now. But I think the general advice I give you is that if you're asked to arbitrate in a country which is not a country you think sounds like a good one, I would ask an arbitration specialist as to whether arbitrating there is a good or bad idea. This is interesting. You may want to choose a country from which you want the arbitral chairperson to be selected, because often if the parties can't agree on the chairperson of the tribunal, the chairperson may be selected from that country. So you might want to think about that. Next slide. You got to include a provision for the number of arbitrators and the procedures for selecting them. There's only two decisions here, one arbitrator or three arbitrators. We generally recommend a panel of three arbitrators. It reduces the chances of arbitrary decisions. If you have one arbitrator and he or she doesn't know the law and is a nutcase, well, then you're stuck with that decision. If you have three arbitrators, of course, that levels it out. Reduces chances of corruption. I don't see that happening much in international arbitration. I put that there anyway. I understand that a lot of international sourcing transaction disputes may not be high dollar disputes. Not all, some may, but for those that are not, there are advantages of choosing one arbitrator. Cheaper, obviously, you only pay the fees of one arbitrator. And one arbitrator is less likely to split the baby. Sometimes panels of three arbitrators are accused of compromised justice. Not the case with one arbitrator. But again, if you have I would consider what is the volume, what is the dollar value of the contract, and if it is over a couple $1 million, or maybe you can make your own decision, I would choose 3 arbitrators rather than sticking with 1 arbitrator. It's a commercial decision. Next slide. That's just an example of a procedure, of a provision you can put in for choosing a panel of 3 arbitrators. Again, you just tack that onto the model arbitration provision. Next slide. Language of the arbitration, very important. Again, the dangers if you don't specify the language, and if you have 2 companies who are different countries that speak different languages, you don't put in what the language of the arbitration is, you're going to have heated bilingual disputes about what the language should be. In fact, I was once in an arbitration representing a U.S. party against a French party. The arbitration clause did not provide what the language was, even though all the documents are in English. The arbitrators eventually ruled that it should be English, but my French adversary refused to talk in English for the first 2 days of the hearing. So these are the kind of expenses that you can avoid. Very, very easy. The arbitration shall be conducted exclusively in the English language. Put it in there. A couple things. Avoid dual language arbitration. Sometimes parties like to say, well, the arbitration will be in Chinese and English. And that's fair and well. It seems like a nice compromise. But it gets very, very expensive at the time of arbitration if everything has to be translated, all your submissions, all of the testimony. So you want to be careful about that, and don't automatically assume that the language of the contract will be the language of the arbitration, as I said. Next slide. Entry of judgment, stipulation. It's a simple provision. Now, the New York Convention provides that every international arbitration clause is that the courts of that country, let me start again. For every country that signs on to the New York Convention Treaty, the courts are treaty obligated to enforce arbitration provisions, foreign arbitration provisions, to enforce foreign arbitration awards. But it's always a good idea to include this little simple provision, and I put it up there on top. Judgment on any awards rendered by the arbitrators may be entered in any court having jurisdiction over the court parties or their assets. It just preserves the right of enforcement, makes it clear, and prevents parties from making frivolous arguments at the time of enforcement. One thing to do is if you want to give a home court exclusive jurisdiction over the enforcement of arbitration awards, that's a bad idea, because you never know where you have to enforce that arbitration provision. Again, you're going to if you get an award and you're awarded money, where you're going to have to start a court action, assuming the other side doesn't pay voluntarily, will be where the assets of that party are located. So if you say only the courts of New York have jurisdiction over enforcement actions, and there's no assets in New York, you're doing yourself a disservice. So it's not. You can say that the parties agree to the non-exclusive jurisdiction, so they submit to the jurisdiction of your home court, but make sure it states that it does not have exclusive jurisdiction. You can go to other competent courts of jurisdiction. Next slide. Okay, provisional injunctive relief. There is conventional wisdom, I hear it a lot, that arbitrators don't have the power to issue preliminary or even permanent injunctive relief. Absolutely false. That's absolutely false. They are. Arbitrators have wide discretion and wide latitude to fashion remedies to do justice. But there are 2 significant limitations on injunctions. And most important is timing, right? When you start an arbitration, particularly if there's 3 arbitrators, it could take months before the arbitration tribunal is selected and appointed and confirmed by the arbitration institution. So during those 2-3 months, there's a vacuum of authority. And people often need injunctions precisely at that time, at the beginning of a dispute. You want to stop someone from doing something. So so the solution is to put in your arbitration clause a provision that preserves the party's right to seek court injunctions in aid of arbitration. You go to the next slide. And there's an example. It's long-winded. I'm not going to read it to you. But it basically says, hey, you know what? We can't, notwithstanding the parties' agreement to arbitrate, this does not waive the parties' right to go to the courts to seek preliminary injunctive relief. Okay. Again, just as I said, avoid adding exclusive home court foreign selection clauses for this type of clause because, again, you never know where you're going to have to go to get that injunction. Maybe you're going to have to go to the courts of Russia to get an injunction. So make sure that it's a non-exclusive clause if you do have such a clause. Lastly, waiver of appeal. This is, again, not critically necessary. It's not critical. It's not essential because it's written into the New York provision that people don't have this appeal, that the parties don't have this appeal, that the courts have to enforce the arbitration award. But as a belt and suspenders, prudent measure, I always recommend that my clients put this simple provision into their international arbitration clauses so there is no confusion about it at the time, that any awards rendered by the arbitrators shall be final and binding, and each party waives to the fullest extent permitted by law any right it may otherwise have under the laws of any jurisdiction to any form of appeal of or any collateral attack against such award. Again, this is a belt and suspenders provision. And I turn it over to Bob.
Okay. So I'm going to spend a few minutes talking about optional provisions that can be added to an arbitration agreement. I'm not going to be talking about all the subjects that might be addressed. As Ted said, when you're deciding what should be in your arbitration agreement, you have to think about what type of disputes are likely to arise, what types of particular enforceability issues might arise in the context of your particular contract to decide what you really need in that arbitration agreement. But I'm going to address a few subjects that I think very frequently are important in the impact that they have on the cost and the effectiveness of the arbitration process. And I also want to make it clear that if you choose a set of arbitration rules of an organization, yes, those rules will govern, but most of those rules provide that any optional provision that you add to the agreement will trump the provisions of the organization's rules. In other words, it will take precedence over the organization's rules if you provide for something that is different than the organization provided for. So you do, I think, as Ted mentioned earlier, have the ability to, in a sense, play God and create the procedure that makes the most sense for your particular transaction. So if we can move to discovery. I want to talk a few moments about discovery because discovery is an enormous driver of cost, potential driver of cost in any dispute. So you need to think very carefully about how much discovery, what type of discovery you're going to have in your proceeding. And in thinking about that question, you should consider whether your company will be at an informational disadvantage compared to your counterparty if a dispute arises and your company can't take discovery. For example, customers in these outsourcing relationships and also new system implementation agreements generally know less than suppliers with respect to most of the matters that might be disputed. The customers have been relying on the effort and expertise of the supplier, and as a result, the supplier probably will know more about the reasons why a system isn't performing properly or why there are cost overruns. So discovery can be expensive, but it can be absolutely necessary in some cases for a party to prevail in its case. Next slide, please. If the arbitration agreement is silent and all you are referring to are the rules of the organization, you may have very, very little discovery because many organizations provide for very little discovery, nothing like a U.S. court proceeding. But you can specify in the arbitration agreement the types of discovery that should be available in the proceeding. For example, document requests, interrogatories, depositions. And you can also impose some limits on the amount of discovery. Furthermore, you can adjust the discovery to be appropriate for the amount in controversy. It is possible to specify that in controversies over $1 million, there is a certain available set of discovery tools and limits on discovery. For disputes that are less than that, maybe less discovery. So you can adjust in the arbitration agreement the type of the amount of discovery that's appropriate on a minor dispute or a major dispute. Next slide. So on this slide, we've given you an example of a provision on discovery that a customer in an outsourcing agreement or a new system implementation might want, at least with respect to your dispute. We are calling for the production of the documents, relevant documents in item I. Depositions of the people that your opponent wants at the hearing. Very important that you have an opportunity to hear what they have to say before you have to cross-examine them at the hearing, because you can do a much better job of cross-examination if you have a preview. But also, it can help you settle the case. Because you will learn more about the case as a result of these depositions, and that will allow you to evaluate the likelihood you're going to succeed if you go forward, and that will inform your judgment as to whether you ought to settle the case. So actually, deposition discovery can be a settlement tool as well as a tool to help you win the case. Next, it's also useful to have the ability to depose additional witnesses that your opponent isn't going to call, because chances are your opponent isn't going to call the best witnesses for your case. So you may want to be able to depose some of their employees who you think might help your position, or you might want to depose some non-parties who might help your position and bring their testimony to bear. Discovery is full of disputes, and so sometimes it's useful to refer to a body of law that the arbitrators can use to resolve disputes when they arise, and one such body of law is the U.S. Federal Rules of Civil Procedure. So it's possible to designate that as the basis for the arbitrators to make their decisions if there are disputes in discovery. Next, let's consider summary disposition procedures. In the U.S., there are procedures for early resolution of a case without a trial, a motion to dismiss, a motion for summary judgment. The idea is that there are situations where there's really no dispute as to what the facts are, so there's no need for a trial evidentiary hearing. Maybe a disagreement on the applicable law, but that can be argued in briefs, and the court can decide what law to apply to the facts. And there could be a very narrow issue that could be considered, and if it goes in a particular way, the case is over. For example, statute of limitations. If the facts are clear when the incident arose that triggered the statute of limitations, don't need a trial or evidentiary hearing. If there's some question about which statute applies, then that's a legal argument. And if it's resolved that the case was brought too late, case is over. And you don't have to spend all the time and money doing all the discovery and dealing with all the other issues and having an evidentiary hearing. So international arbitrators generally are not permitted by the organizational rules to issue these kinds of preliminary decisions, summary judgment rulings, motions to dismiss. Even when a party is plainly entitled to it, typically all the factual legal issues have to be considered at the same time. So to streamline the procedure, you should consider adding a provision that provides for summary disposition at an early stage in the case, if it's appropriate. And on the next slide, we have offered an example of the language to accomplish that. Next slide, please. So arbitration is generally less costly than litigation, but it still can be quite costly. And there are other alternative dispute resolution mechanisms that can be invoked to avoid the cost of an arbitration, such as mandatory negotiation or mediation of the dispute prior to arbitration. So your arbitration clause can provide that, and it will require the parties to negotiate or mediate. Mediation is a negotiation with a neutral in between that helps the parties sort of talk to each other. Now, if you go that route, you want to make sure that there isn't an abuse. using those procedures to delay things, so you want to have strict and short deadlines in the agreement to accomplish the negotiation and mediation. And you got to make sure that the language says if the mediation is unsuccessful, you shall arbitrate. You're getting the impression, I hope, that shall and may make a big difference here in terms of whether the arbitration agreement is enforceable. So you absolutely must make it clear that if the mediation is unsuccessful, the parties shall arbitrate. And you should require executives with decision-making authority to engage in these negotiations and mediations for it to be meaningful. Two additional thoughts on how you can apply additional pressure to settle in the mediation context. You can provide in the agreement that a mediator will make a non-binding recommendation on the merits at the end of the mediation if the case isn't settled. That means the mediator, listens to the parties, tries to make a settlement happen, uses his best negotiating techniques, but if at the end nothing is settled, the mediator says, look, if this case were tried, I think the plaintiff would win a judgment of $5 million. And what does that do? Well, it creates some pressure on the executives who are participating because nobody likes to be second-guessed. And if they walk away from a negotiation where somebody has recommended it be settled for $5 million or something in that neighborhood, and they go to arbitration and they fail to recover anything at all, they'll be second-guessed, and nobody likes being second-guessed. So it applies some pressure after the arbitration for the parties to keep talking to each other and maybe settle the case. And you can amplify that by providing that the attorney's fees will be shifted to the losing party if based upon how the arbitration outcome compares to the mediator's recommendation. So finally, let's talk just very quickly about an expedited arbitration provision. The arbitration process should fit the type and seriousness of the dispute, and in some cases, as Ted and Mark have commented on, there may be a need for speed, but not necessarily need for an expensive procedure. It can be particularly suited to address lower stakes disputes. And for example, in outsourcing relationships, there can be an accumulation of unresolved smaller disputes that can really add up to a large number and can adversely affect a business relationship. And they add up because there's no streamlined resolution mechanism to get them resolved. So they just mount up. So you can address these types of disputes by providing an arbitration process in the agreement for claims under a specified damage amount. For example, $250,000. And the procedure would work something like this, one type of procedure. It would provide for a single arbitrator, a very short briefing schedule, and very short page limits. You're talking about completing everything maybe in 30 days. Each side submits a settlement offer at the time that they submit their brief. And no discovery is compelled, but participants can informally ask each other for discovery and comment on the failure to produce the documents to the arbitrator if they aren't produced. And the dispute can be settled by accepting the counterparty's settlement offer that they make at the time they submit their brief. If it's not settled, very short hearing, 2-hour maximum, let's say, specify whatever makes sense for your particular transaction. And here's the key. For the award, the arbitrator can select only one or the other of the settlement offers. Nothing in between, nothing more, nothing less, one or the other, plaintiff or defendant. And the losing party pays the arbitration costs and the prevailing party's attorney's fees. What does this process do? It encourages a reasonable settlement offer because the parties know that the arbitrator is going to pick either one or the other. So they have to come up with a reasonable number or they're going to lose that arbitration. And so what does that do? That encourages settlement because it's likely that those offers are going to be relatively close very often, and that allows the parties very often to reach a settlement without even going to the last stage, which is having the arbitrator decide. So those are a few thoughts about provisions that can be added to an arbitration agreement that can have a significant impact on cost and effectiveness. And now I'm going to turn the conversation over to Mark, who's going to talk about the enforcement of arbitration awards in India. Mark?
Thank you very much, Next slide, please. So I think the first thing to say about enforcement of arbitration awards in India is that India is a signatory to the New York Convention, and as such, in principle, permits enforcement of arbitral awards under that convention. And such awards should be enforced as a decree of the Indian courts without substantial argument on the merits. However, as most people on the call will be aware, there have been substantial practical difficulties for parties enforcing such awards in India in terms of both the time it takes and the procedural steps involved. Now, by way of background, the key legal framework is set out on the slide, the Arbitration and Conciliation Act of 1996. That was amended in 2015 to try and make India a more attractive jurisdiction for arbitration, including the enforcement of awards. One key point to note about the New York Convention and its application in India is that the Arbitration and Conciliation Act limits enforcement of awards to awards issued in a jurisdiction which has been notified in the official gazette as being a signatory to the New York Convention. Now, that is only about 50 of the 150 New York Convention states, so you do need to check if the jurisdiction in which an award was issued is one of those 50. Now, those jurisdictions do include the United Kingdom, the US, China, Hong Kong, Singapore and France, so a lot of the key arbitral jurisdictions. And in terms of the formal requirements, they're relatively standard, providing authenticated copies of the award and the agreement, evidence that the award is valid and enforceable at the seat of the arbitration, and translations of the relevant documents. Next slide, please. Now, as with most jurisdictions, there are various grounds on which the Indian courts can refuse to enforce an award. And as one would anticipate, grounds such as procedural irregularities can be used to try and frustrate the enforcement of an award and invite challenges going to the jurisdiction of the tribunal and a party's participation in the arbitral process. Equally, there have been some cases regarding whether the subject matter of awards amounts to commercial matters under the law of India. But these types of issues are raised in many jurisdictions subject to the New York Convention. And the key problem with enforcement in India has been the broad interpretation given to the ground at the bottom of the slide. That is, that an award is contrary to the public policy of India. And a number of decisions have equated this with the test of whether applying Indian law, the result of the arbitration might have been different. I mean, alternatively, in a number of cases, it's simply taken a very long time for awards to be enforced due to multiple appeals and the speed at which the Indian court system operates. By way of example, the two cases referred to in the final bullet points on the slide are seminal cases in Indian arbitration law. Both of them went to the Indian Supreme Court and took around 6 years to be resolved. And the first one was a claim for repayment of amounts paid for goods which were not delivered under a charter party. And the argument was this was contrary to Indian public policy because it was a penalty. And the second was a dispute over reimbursement for defective goods. And the argument here was that the award was contrary to the terms of the party's contract and therefore contrary to the public policy of India. And you can see how, if those sorts of arguments can be raised, there are obviously difficulties in enforcing without a substantial rehearing on the merits. However, the Sri Mahal decision at the bottom did narrow the scope for future challenges in this regard and was widely seen as a pro-arbitration step. However, some uncertainty remained. Next slide, please. And then in 2015, the amendment legislation, the 2015 Act, was designed to deal with the public policy exception, restricting the situations in which the court should allow substantive argument on that ground. It also ensured that such issues were dealt with by the high courts, which are the third tier of the courts in India, whereas previously lower courts also had jurisdiction. And it's to be hoped these changes will improve the position, but the approach of the courts will have to be judged over time. Next slide, please. One other factor which suggests that India will improve its enforcement record going forward is the opening of the Mumbai Centre for International Arbitration, which is due later this month or perhaps in early October. The idea behind this demonstrates that there is a political will to improve India as a venue for arbitration in an attempt to keep business that's currently going to Singapore and Hong Kong. Now, this political ambition can only be realised by a continued focus on improving enforcement options. So where does all that leave us in practice? I think it's too early to rely on dramatic improvements to the Indian system. Therefore, for the time being, enforcement in India is to be avoided if possible. And the sort of steps you might consider taking to avoid or mitigate these problems would be, first of all, ensuring the seat of the arbitration is in a jurisdiction that's been notified in the Gazette and is obviously a New York Convention state. Secondly, check if the contracting party has assets outside India in jurisdictions where enforcement is more straightforward. If it doesn't, seek guarantees or performance bonds from entities with assets outside India, or seek to agree escrow arrangements to provide security for unperformed or underperformed obligations. And finally, keep an eye on the position with the Indian courts to see if there is a real improvement. I'll now hand over to Ted to talk about China.
Ted, I think that we're not hearing.
I'm a little wary of the time, so I'm going to make this expedited. I have a lot of experience actually conducting arbitration, Chinese arbitration arbitrations against Chinese parties, as well as drafting arbitration clauses in Chinese joint venture contracts, etc. Let me sort of summarize. When you are entering into a contract with a Chinese party, and that assumes you're not Chinese yourself, you have two choices: arbitrate inside China or arbitrate outside China. If you arbitrate outside China, the award that is issued by the tribunal will be enforceable in China under the New York Convention. If you arbitrate inside China, that's not the case. Then that'll be called a foreign-related arbitral award, and it's subject to its own. The enforcement of a foreign-related arbitral award is subject to its own statute in China rather than the treaty of the New York Convention. Next slide. Let me just give you some tips, okay? Arbitrate outside mainland China if you can. If you can't avoid it, arbitrate outside mainland China. Hong Kong, that's a fine place to arbitrate because Hong Kong and Beijing have an arrangement where Beijing treats Hong Kong awards issued in Hong Kong as awards like any other New York Convention state. That's tip number one. Tip number two is, if you have to arbitrate inside China because you lack the negotiating power, the other side insists upon it, make sure that to run your arbitration clause by an expert. Make sure that your arbitration clause provides that the language, the arbitration will be in English, that the arbitrator will not be Chinese, because the default under a lot of these Chinese arbitration rules is that the arbitration in China will be in the Chinese language and will be arbitrated by a Chinese national unless the contract provides otherwise. What I like to advise my clients is start Far West and then agree to settle somewhere in Asia. So demand arbitration in New York or Paris under the ICC. The Chinese side might demand arbitration inside China and then settle on arbitration in Singapore or Hong Kong under the Singapore rules or the Hong Kong rules, and you'll be okay. Next slide. Okay, Mark, I think a lot of things Mark said about India apply to China. There are risks, and those kind of things that Mark said you can put into your contract, performance bonds, et cetera. If you can get them, of course they're a great idea. The fact of the matter is China is a member of the New York Convention, but some countries are better adhering to their treaty obligations than others, and there is some concern about Chinese enforcing arbitration awards. There's a lack of reliable statistics, especially at the local level when you have to start enforcing. Whenever you enforce an arbitration award, you first have to go to the local level courts and try to enforce it. Those local level courts are often protectionist, sometimes they're corrupt, and they may refuse to enforce awards which should plainly be enforced under the New York Convention. There's also sometimes you deal with extra arbitration tactics. It's not uncommon where Chinese parties may turn you into the government, et cetera. But the reality is this: unless the Chinese party has assets outside China that are attachable in a sufficient amount to satisfy a future arbitration award, international arbitration is the best game in town. You don't want to litigate in Chinese courts. You don't want to litigate in the U.S. courts if there are no assets here, because the Chinese courts will not enforce a U.S. litigation. So international arbitration in a New York Convention states the best game in town. It's getting better. In 1995, there is a Supreme People's Court order that all lower court refusals to enforce foreign arbitration awards go up for automatic review by the Supreme People's Court in Beijing. The reason being that the Supreme People's Court has a more national than parochial perspective. They want foreign companies to invest in China, and if China starts getting a bad reputation of not enforcing international arbitration awards, that's not good for China. So things are definitely improving, and it's the best game in town. But I'm happy to discuss this with anyone separate if you want to give me a call. I know this is a discussion that is one that is evolving and people may have a lot of questions about. Thank you.
Thank you. We've gotten a few good questions, and we will seek to respond to those, but in light of the time, that wraps up today's program. And on behalf of Mayor Brown and my colleagues, thank you for your time. We hope you found this program useful, and please be on the lookout for future invitations to our Business and Technology Sourcing webinar series. If you have ideas for future programs, please do email us at bts@mayorbrown.com. Thank you. I will now turn the call over to the operator for closing formalities.